Thank you, Team Taxmann, for inviting me again on a very important judgment of Supreme Court. In fact, a very warm good evening to all the participants. And we are elated to share again analysis of a Supreme Court ruling. Last time we had done an analysis of very popular judgment, Rainbow Paper. And again, its review. Today, we are again going to discuss a very, very important judgment of Honorable Supreme Court, which has again, I would say, disrupted the whole process. And it not in the negative sense, but in the positive sense, that the power of recall, which normally tribunals like NCLT, NCLAT, and various other tribunals do not use more often. However, in this particular judgment, we will understand the importance of power of recall, also with regard to duties of insolvency professional with respect to claims, when they should take the claims, what they should treat the claims, and how the resolution plan should deal with a particular claim. So we are going to discuss about the powers of tribunal. We are going to discuss in what circumstances can a recall be triggered. We will also discuss what is the difference between recall and review. Furthermore, in cases like this one, where the important asset of the company is a land, which is a leasehold land, we will also discuss how the impact of even an operational creditor, but having a special right for the property, needs to be dealt with, and you cannot do away by taking that the claim is not filed. So, without wasting further time, I will start with why this judgment is so important and why this particular judgment is a must read for all the practitioners, whether it is insolvency professional, whether it is resolution applicant, whether it is banker, or whether it is any governmental authority. Because this judgment touches each and everyone. And I'm sure after this ruling, there is going to be many resolution plans being challenged on the ground of ex-parte. So I will discuss all of them, but let us first discuss the facts of the case, and then we will go step by step to discuss the provisions of law, how the law has to be interpreted. Why this judgment is very important? If you see the timeline, the application of the appellant in this particular case was Greater Noida Authority. So now this Greater Noida Authority filed application with regard to their claim. They asked various things in their application that I am going to come in further slides. But the point is their application got rejected in NCLT. Their application got rejected in NCLAT. However, Supreme Court has reversed the orders of both NCLT and NCLAT, meaning thereby that orders which were passed by both the tribunals below in the hierarchy, in the judicial hierarchy, have been reversed by Honorable Apex Court. Second important thing is a plan which was approved and implemented got set aside by the Honorable Apex Court, seeing the infirmity in the plan approval. So that is very important that once the plan is approved by an authority, now it is duty of authority also to look into important claims which might disrupt the implementation of resolution plan or which are adversely affecting any particular authority. So this is something like Rainbow Papers, wherein again the NCLT and NCLAT did not entertain the application of state tax, and Honorable Apex Court rejected the resolution plan, or I would say set aside the resolution plan and treated them as a secured creditor. Similarly, in this particular case, it has some trappings of similar to that of Rainbow Papers. However, in this particular case, the claim is of an authority which had given a leasehold land to the corporate debtor. Now, the land which was leased to the corporate debtor was the only land of the corporate debtor on which the project was made. So the complete plan, which is based on the project, which is based on or which is arising out of the same land, means that the complete resolution plan is not viable if this particular aspect was considered. And therefore, Honorable Apex Court has set aside the approval of resolution plan. So it's an extraordinary judgment in extraordinary circumstances. It should not be taken as a rule, but the glaring mistakes which have been committed in the process, whether by professional, whether by committee of creditors, or whether by tribunals, should be taken into consideration so that such a difference, or I would say such an indifference to the claimants or the creditors, does not prove fatal for the plan which is to be approved by the honorable tribunal. So let us go, and being a lawyer, I always start with dates and events. So you see, dates are very important in this particular case. Here, the corporate debtor went into insolvency in 2019. Appellant, that is in this particular case, Noida Authority, Greater Noida Authority, filed a claim of around 43 crores in January 2020. By Feb 2020, the RP rejected the claim of the authority, terming it as incorrect claim form and stating that you have filed a wrong form as a financial creditor. You should file a correct form as operational creditor. This is a very important aspect where the RP is stating that I am rejecting your form, your claim, because it is in the wrong form. Why this is important? Because again, coming to the ratio of the judgment, a wrong claim form, can it be fatal to the claim itself? Answer is in negative. So a claim form, even if it is incorrect, claim has to be taken into consideration. What be that as it may, the claim form was rejected by the RP, and the exact claim form which the RP suggested was not filed. On the other side, the authority, I am talking about the claimant authority, that is the Greater Noida Authority, did not file any corrected form or did not approach honorable tribunal that I have been wrongly rejected. So they did not raise any grievance with regard to claim. And by that time, August 2020, NCLT approved the plan. Now, when the NCLT approved the plan, the operational creditor treatment was given to this particular authority. However, it was treated as per probably the evidence and the books of accounts available with the RP. Now, when, as per the plan, some amount was given to the authority, the Noida Authority, they came to know that the plant has been approved and now the implementation has started. They came to know in 24 September 2020 that the intimation of the plan is approved. 6th October 2020, they filed an application before NCLT questioning the plan and the RP's decision of treating them as an operational creditor. So you see, first application by the authority, by the Noida Authority, was filed in 6th October 2020. Then they filed another application for recall. So that is, you see, 24 September 2020, plan intimation, 6th October 2020, an application questioning the plan. Second application asking for recall was filed on 15th March. So basically, two applications were filed with NCLT post approval of plan, alleging wrong treatment, resolution plan being passed without calling them in the meetings, and third, recall of the resolution plan. Now, these two applications which were filed by the Noida Authority came to be rejected, or I would say dismissed by the NCLT, and thereafter the appellant approached NCLAT. In NCLAT, they again challenge the status as they had challenged it before NCLT of being a financial creditor. Second, to be treated as secured financial creditor, not being called in the COC, and thereby alleging that the resolution plan is violative because it did not consider them. Again, NCLAT dismissed the application. So the factual background, probably I have tried to cover the major action points with regard to the judgment that NCLT rejected. NCLAT also rejected the application of the Noida authority, saying that, sorry, the plan is approved correctly. Now let us see what was the financial impact on the appellant. So the claim which was made by the appellant, that is the Greater Noida Authority, was 43 crores. So as per them, it was approximately 43.40 crores. According to the RP, according to probably the books of accounts or the proof, because he rejected the claim form filed by the Noida Authority. However, according to him, what he had considered, it was 13.47 crores. And accordingly, they had paid 1.34 crores in the plan. And this was the reason that they got something under the plan that he was intimating them that you are going to get this much payment. This is when the Greater Noida Authority moved court, because after approval of plan, only when they got the intimation that we have been treated as an operational creditor, we are only paid 1.34 crores, there is a grievance, we have been wrongly ousted. So this was the triggering point for the appellant to challenge the decision of approval of resolution plan. Now, what were the broad allegations? I will come on to each and every allegation, but the broad allegation of the authority, of the Noida Authority, was claimant, they were the claimant and they were wrongly treated as operational creditor. Their correct classification is financial creditor. So this was their allegation. Because they were financial creditor, they should have been called in the committee of creditors. They were not called in the COC meeting. Third, because the land on which the project was standing, without considering their claim, without considering them as a creditor, the complete feasibility of the plan is in danger, and therefore the plan cannot be approved without considering them with appropriate classification and appropriate payment. That was their broad allegation. Now let us analyze point by point what was the allegation, what was the stand of the resolution professional as well as committee of creditors and the SRA, and what did Honorable Apex Court held. So first thing, the claim which was filed by the Greater Noida Authority was rejected by the RP. So the court went on to analyze the regulations 7 and 8. Now, we all know regulation 7 and 8 talks about financial creditor and operational creditor. The language used is a creditor will be claiming himself to be an operational creditor, claiming himself to be a financial creditor. So therefore, the language used in the regulation gives clarity that the person who files the claim is, in his understanding, claiming to be a particular class of creditor. So very importantly, the ratio which comes from the analyzation of the language of regulation is that the person who is filing a claim is filing a claim according to his understanding. So if I am a claimant, probably my understanding is I am operational creditor, I may be wrong. If my understanding is I am a financial creditor, I may be wrong. But I am filing a claim, and therefore wrong filing of claim form should not come in the way for considering my claim. Suppose the RP thinks that I am not a financial creditor, I am an operational creditor. he can very well take that claim. Just because I have not filed the correct form according to the RP's point of view, that will not disentitle my claim. Secondly, these regulations are only directory. So RP cannot fasten that if you have not filed, I will not consider. And again, we have elaborately discussed this point in Rainbow Papers also, that even if a claim is appearing in the books of accounts, it is the duty of the RP to consider same. And in this case, it is a very gross case because the claimant has also filed a claim form. So there are two things. Claim was appearing in the books. Also, he has filed a claim form. So the duty of RP should be to see the amount of the claim also. Now, second important thing, whether the person who is claiming to be a financial creditor is a financial creditor or not. So the appellant claimed to be a financial creditor. Now the appellant tried to suggest that he was a financial creditor because he had given a lease and that was being used by the company and the project was made. So they have in turn funded the project. Now, this particular argument was rejected by the Apex Court by relying on a previous judgment of Apex Court in a similar situation. The citation is New Okla Development Authority versus Anand Sonbhadra, wherein Honorable Apex Court said that the lease is the determination of a creditor classification. Now, if the lease is an operational lease, sorry, that will be an operational creditor. If the lease is a financial lease, then the claimant can treat himself as a financial creditor. So, Supreme Court repelled the argument of being a financial creditor by relying on the previous judgment, and also the appellant was not able to satisfy on the ground of being a financial lease by the authority. So therefore, one allegation of Greater Noida Authority was rejected by the Apex Court by holding it to be an operational creditor. So this is very clear that they did not accept the argument of being a financial creditor, but treating them as an operational creditor. Now comes the second point, whether the claimant, whether it's an FC or OC, financial creditor or an operational creditor is a different thing. But whether this particular appellant is a secured creditor or not, the second challenge. So the challenge is whether a person, even if he is not a financial creditor, can he be a secured creditor? Now, the authority is a statutory undertaking established under Section 3 of UP Industrial Area Development Act. Under this act, they were an authority, and under this particular act, they have power under Section 13, 13A, and 14. Now, these three sections talks about creation of charge, recovery as an arrears of land revenue, and in case of non-payment, forfeiture and of the lease and then transfer it to somebody else. Now, just for the ready reference, I have just extracted the relevant section. Now you see section 13A of UP Industrial Area Development Act. What it says, any amount payable to the authority under section 13 shall constitute a charge over the property and may be recovered as arrears of land revenue. That means whatever is amount payable to the authority, it will be a charge over the property of whom? Of the property which is being given on lease. And they will recover it as an arrears of land revenue. They can also attach the property, sell the property under the relevant sections of the UP Municipal Corporation Act. We are not concerned with all this. What we are concerned is, by virtue of section 13A, a charge is created over the property. So basically, can we say that it's a secured creditor? Let us read section 14. Forfeiture for breach of conditions of transfer. In case of non-payment, any installment of the transfer by the authority it will be taken away by the authority. It will be forfeited by the authority. The site would be resumed, resumption of the site. That is, it will come back to the authority. The point is that there is a charge over the property. And second, if the non-payment is there, they can always forfeit. They can always give it to somebody else. So the long and short of this is that the creditor should be treated as a secured creditor. Now, secured and unsecured, I suppose, is clear. Operational and financial is clear. I have discussed both these points. If there are any queries, we will discuss it at the end of session. We will keep around 15 minutes for queries. Now let us come on. What was the question of law which Honorable Apex Court had to decide? So I have first touched upon the merits of the content of the claimant, whether that claimant is correct or incorrect. Now, whether this particular thing, which was not before the court, the claimant was not there, his claim was not there, and his claim was wrongly classified. These things, whether they will prove to be so fatal to set aside the resolution plan. So, question of law framed by Honorable Apex Court are whether under Section 60, subsection 5, can recall of an order of approval of plan be passed, whether the application for recall of the order was barred by time because it came later, whether plan put forward by the resolution applicant did not meet the requirement of Section 30, subsection 2, read with Regulation 37 and 38, and since the plan is approved, what relief can be granted. So, when Honorable Apex Court started framing this question of law, the first thing and the important thing which was discussed was of recall of the powers of the court. So, can a court recall its own power order which is implemented and binding on everybody? Whether a resolution plan, once approved, can be recalled when the time period has lapsed. Technically, the time period of appeal has lapsed. So, while discussing this issue, Apex Court discussed Rule 11 of NCLT rules. Now, we all know that Rule 11 of NCLT rules talks about inherent powers. We know NCLT is a creature of statute under the main parent law, that is the Companies Act 2013. Now, Companies Act created NCLT, and for that act, they made tribunal by way of rules. So, tribunal constituted under the act, governed by rules. Now, under the rules, they say that Rule 11 is the inherent power. So, they can, that means NCLT or NCLAT, have inherent powers for meeting the ends of justice or abuse. If somebody is trying to abuse the process, they can prevent the abuse by invoking their inherent powers. So the question was, these type of inherent powers, can we compare it with the section 151 of CPC? So Apex Court, while juxtaposing this Rule 11 with section 151 of CPC, discussed about a 4-judge bench judgment of Manohar Lal Chopra, wherein the inherent power conferred upon the court, it is by virtue of them doing justice. It need not be explicitly defined. This was the interpretation in the judgment of Manohar Lal Chopra. Then they also referred to judgment of Grindlay's Bank. Now, in the judgment of Grindlay's Bank also, wherein there was a industrial tribunal and their power to recall was questioned. In that particular judgment also, Honorable Apex Court had held that to meet the end of justice, this particular power to recall can be exercised by the tribunal. So basically, the tribunal, though it is not strictly governed by CPC, they can and they should, to meet the ends of justice, use their power of recall if required. If something important comes before them which miss their attention, or it is a miscarriage of justice, they should immediately recall their order. Now, while discussing recall, Apex court discussed the difference between review and recall because it was argued that Apex court can Apex court had allowed recall, and this particular would mean reviewing the resolution plan. So the court also went ahead and discussed the difference between review and recall. Now, court also said that there could be two types of review. One review could be procedural review, one review could be review and merits. Now, if there is a procedural review, that there is a problem with the procedure being followed, it is misappropriately handled, there is a wrongful procedure followed, and there could be a review on merits, whether the law was followed, whether apparently there is a mistake of facts of merits on the face of that, then the review could be permitted. Now, when review is sought for a procedural defect, it can be done on the face of it. Mistake apparent on record, review can be done. But in this particular case, a review could not be done because it will tend to amount to changing the complete resolution plan. So therefore, court went ahead and discussed what do we mean by recall and in what circumstances recall can be done. So this was clear that this particular case is not a case of review, but it is a case of recall. So in what circumstances can the recall of an order be done? The proceeding culminating into an order suffer from inherent jurisdiction or jurisdiction lacking is there, which is patent on record. If there is a fraud committed by one of the party, there has been mistake of the court for a party, or a necessary party is not before the court, or is ignored, or is not made the party in the proceeding. So if a party is not there, who is going to be agreed by the approval of the plan, then in that particular case, recall power can be exercised by the court. So broadly speaking, if there is a patent illegality with regard to jurisdiction, if it is prejudicing a party and that party is not made a party before the court, or by ignoring that party an order is passed, or by that party has not come to the court because they were not made a party by the appropriate, maybe the petitioner or maybe the applicant or maybe the appellant. So in that case, if something is done, recall power as inherent. Now, another argument is if the inherent powers are there, whether recall should be mentioned in the rules. The court said that if to do a justice, a order of recall has to be made, then there is no statutory prohibition to stop the court. If there was a prohibition in the court, then only appeal would lie. Because one of the argument from the respondent side was, sir, they should go for appeal. They should not go for recall. So they have made a wrong application. And today they cannot go for appeal because they are in appeal for a wrong application. So court still went ahead and said, recall can be done. Recall is not prohibitory in nature. And if the NCLT has applied mind and rejected the recall, we can very well correct the situation. Relying on 5-judge bench order of Honorable NCLAT, wherein power of recall was discussed, which subsequently was also confirmed by two-judge bench of Honorable Apex Court, with regard to powers of recall. Supreme Court again concurred with the view taken in this Union Bank of India versus Dinkar matter, wherein it was said that if a necessary party has not been served, necessary party was not before the tribunal, or where some fraud is played on the court in obtaining a judgment, then in this particular situation, tribunal has the power to recall. Further, there is no power otherwise prohibiting to exercise such a power. So there has to be a unfettered power to do something. It should not be prohibited or restricted. Now, in this particular case, it was not prohibited. So therefore, the exercise of inherent power by the court to meet the ends of justice is not getting fettered by any prohibition. Further, while discussing section 60 subsection 5 clause C, Apex Court also was of the view that it's a non-obstinate section and any question of priorities, whether it is in law or facts, can be decided by the tribunal. And therefore, the proceedings before the tribunal and the powers with the tribunal are very important to decide in such a particular case when it is brought to their notice that some plan has been passed with maybe playing the fraud or maybe without hearing the necessary party. Now, here, discussing the power of recall, again, the pointers which are required or the parameters which are required to be seen are the order is without jurisdiction, the party aggrieved is not served with the notice of proceeding, the order has been obtained by a misrepresentation of facts. In this particular case, so our case is that of Greater Noida Authority, where they were claiming to be a financial creditor. So that has been decided. In the previous slide, we have discussed, they were considered to be operational creditor and rightly so. So Apex Court confirmed the classification as an operational creditor, not as a financial creditor, which was claimed by the appellant. Second issue, whether they are secured creditor or not. Yes, they are secured by virtue of their section 14, 13A and the respective law. Just like in Rainbow, we had that section 48 of Gujarat VAT Act. Similarly to this, Noida Authority taking power from UP Industrial Act, they were also classified as secured creditor. Third, if they were also classified as an operational creditor, because their claim was more than 10% of the total claim, they should have been invited in the committee of creditors. So therefore, the proceeding in the COCs were ex parte without taking into consideration the operational creditor who is having statutory right to participate in the meeting. Secondly, the RP in the resolution plan misrepresented that he did not receive any claim. Because he did not receive the correct claim form, he misrepresented that he had not got any claim form. So here there is a very important learning for the RP. If you have not got the correct claim form according to your opinion, then also that claim has to be considered. You cannot say you have not received the claim. You have to take a liberal approach and consider that you have got the claim. Maybe your understanding of claim category be incorrect, but to say that you did not receive a claim is incorrect. You received a claim and you have classified, maybe right or wrong. That's something for the court to decide. But don't take a decision that you did not receive a claim. Further, Apex Court also scrutinized the working of the tribunals, saying that it was a mistake on the part of the adjudicating authority to approve the plan. So they approved the plan without taking into consideration the section 30 subsection 2, which said that all the claimants should be taken into consideration. They should not be put under the carpet. They should be classified properly. They should be considered properly. And if they have a right to be heard in the COC, they should be invited also. So all these grounds. So ground number 1, wrong classification. Ground number 2, wrong filing of claim. Ground number 3, secured or unsecured financial creditor. All these 3 culminated to be a valid ground for recall. So Apex Court held that the particular ground which the appellant is alleging are correct grounds for recalling of the order of approval of resolution plan. However, they gave a rider that even if the recall application is maintainable, that does not mean that the right to appeal has been curtailed. So there is a right of appeal also, and there is a power to recall also. So power to recall should have been exercised by the tribunal at first place when the appellant before the court approached NCLT for recalling of the order. So if the recalling application would have been considered, then probably the appeal would not have been there. But to say that because recalling was incorrect, therefore appeal should go away is wrong. So Honorable Apex Court gave 2 findings. Recall application also maintainable, appeal also maintainable. So this is a very important learning for all lawyer friends here, that application of recall does not disentitle the right to appeal. So appeal can always be done, but if you can convince the first court that there should be a recall, then you should always try for getting this particular additional facts before the tribunal and try for a recall. Since two applications were filed, the second allegation was that the application was filed belatedly for recall. So that also got covered because that time period of COVID 2020, 21, and 22, Honorable Apex Court had taken suo motu cognizance and for the purposes of all the laws extended the limitation period. So the argument of delay with regard to recall application was rejected again by the Honorable Apex Court. So the first point, that the claim of 43 crores was not accepted and claim only of 13 crores was accepted by the RP or considered by the RP during the resolution plan, was rejected because their claim was not considered, and not considered as a secured financial creditor has to be done away with. The error which is apparent on record is also that they were not called in the meeting of committee of creditors because they were having more than 10% of the claim. Hence, they should have been invited to the committee of creditors, and Honorable Apex Court suggested that the plan be set aside. Ordered that plan should be set aside and suggested that it should go back to the COC. It should go back to the COC because NCLAT did not consider these people were secured creditors. Because of their Parent Act, Section 13A, they have a charge over the property and therefore they are secured, and hence a treatment of fair and equitable should be given to them. Without this being done, the plan cannot be approved because the plan loses its feasibility, because the only land in the plan was of the appellant. The whole project was standing on the land of the Greater Noida Authority. So without that land being available, further, no decision on the resolution plan can be taken. Therefore, also the feasibility will go in tantrums if the plan does not consider this particular aspect of the appellant. Because if they terminate the lease, if they take away the land, there cannot be any plan. So therefore, they are placed at a better footing, and therefore the feasibility will not survive. Feasibility is an important aspect which probably is for the first time being discussed by Honorable Apex Court, and therefore from now onwards, all the resolution plan will require to be checked on the feasibility by the Honorable Tribunal as well as by the RPs. Because if the only asset of the company, the only asset which is being held by the company belongs to somebody else, and you are trying to create the complete resolution plan on the basis of that asset, and you are not considering the claim accurately of the person who has given you that asset. Like in the case of telecom, if you are discussing about spectrum and bringing a resolution plan, and the Department of Telecom says, sorry, we will not give you the spectrum. We will not continue the spectrum. Let's say you are having a mining company, there are mining rights. Now in mining rights, if the government is not extending the mining rights, or they are asking that you have not paid the dues, sorry, we will not continue. Or if you are having a lease property and the lease will get terminated because of the outstanding due, such type of situation might arise, and it might lead to the resolution plan being set aside or proved fatal for the purpose of the corporate debtor. So this is the most important thing. And because of this, I would say, going to the root of the matter, these allegations proved to be correct partially, not completely. And therefore, the matter has been sent back to the COC for resubmission after considering all these issues. So the issues which have been highlighted by the Honorable Apex Court have to be considered, and then they will have to go back to their boardroom, call a COC, take into consideration Greater Noida Authority, and then come out with an appropriate plan, if feasible, for all the stakeholders. So I think I have tried to cover it in the time allotted to me. In fact, we will be sharing you this particular presentation, and you can also read our article, which is also on the Taxmann with regard to this particular resolution plan recall order. And now the floor is open for your question answers. I think we have good number of attendees. Yes, attendees, you can post your question in Q&A box. I hope all the participants are able to hear me. Participants, I can see your names. Please put your queries in Q&A box. And I hope if there are any queries with regard to judgment or even otherwise, you can post it here with regard to impact of this judgment. So attendees, do you have any query? I can see Mr. Akshay, Mr. Mehta, Mr. Verma, Mr. Vitlani, Mr. Gupta. Okay, so we have query from Mr. Advani. What impact will this judgment have on government tax authorities who can create charge on property? So, Mr. Advani, your question is very good. See, if you talk about government tax authorities, let us discuss tax authorities by the law in which they are claiming it. So, if you talk about income tax, we are covered by the Supreme Court judgment in Monet's part. If you are talking about state tax, that's the erstwhile law, pre-GST law. So then we will have to go by the rainbow paper to be treated as secured creditor. If you are talking about GST Act today, then GST Act specifically gives way to IBC. So they will be not ranking before the other creditors, will be treated as an operational creditors only in the government dues category, not as a secured creditor. Then, if you are talking about customs, we have another judgment of Honorable Apex Court in the matter of Sundaresh Bhatt versus CBIC. So, in that, Honorable Chief Justice, the author of the judgment, has already held that the indirect taxes also will be subservient to IBC. So, when you are asking about government tax authorities, you will have to see which tax authorities and under which law, state, central, and the implication of that particular law. So these all three things will have to be seen. I hope I have answered, Mr. Rajesh. Any other queries from other participants? I think there are no further queries from the participants. So we have another 5 minutes. If you have any other query, we can even discuss other queries. Even apart from this judgment, if you have any query on the resolution plan, we can discuss the same. By the time query comes, uh, my views on this particular judgment and otherwise is that nowadays it's not the fact, and I think we should not be taken by this staircases concept that once something is decided by NCLT and NCLAT, that will attain finality or will get the blessings of apex court. So sometimes I have seen that, see, this is a very risky proposition for a resolution applicant, because now, see, after 2 years of the plan approval by the first authority, confirmed by the second authority, the clock is turned back. So sometimes there could be a substantial investment by the resolution applicant. And therefore, there should be some type of, I would say, contingent fund, some type of funds which are being there with the RP to litigate all this. And secondly, do not shun away any creditors without hearing them or without properly dealing with them. And I have seen that, like in this particular case, it is a handsome amount of 43 crores which was claimed by the appellant. Now, if a person is claiming 43 crores and there is a gray area, let's say there is an interpretational issue, there is a very small error on the claim filing form, this should not be taken as so fatal that you don't take the claim only. You should consider the claim. And obviously, IBC is an evolving concept, an evolving law. We don't know tomorrow a judgment might come and it might change our views. We have seen many contradictory judgments also in the 7 years regime. But to shun away anybody outrightly would not be proper on the part of any insolvency professional or committee of creditors. In fact, I was dealing with a real estate resolution plan recently, and there have been conflicting judgment of tribunals whether the claims paid in cash should be considered or not, whether the claims coming after the approval of resolution plan by the COC should be considered or not. And the recent amendment says that the claims which come belatedly or beyond the period of approval of plan or probably after 90 days, should they be considered? They should be considered by the COC. Now, I am of the personal view that tomorrow this might also get challenged, that who are the committee of creditors to decide on my claim. My claim should be decided by the RP, and if in accordance with law it is allowed, it should be allowed. Why the committee of creditors who are already in charge will lose their control by accepting a claim which comes beyond the timeline, but which otherwise is reflected in the books, is confirmed in the books, and also corroborated by the evidences which is produced. So I know there is going to be a big mayhem because of the claims, but my suggestion to all the colleagues is that kindly see what is a claim, what is the impact of that claim, and whether that claim can disrupt the resolution plan process. So, Mr. Rajesh, I think your another query is that can the state tax authority recall orders prior to renewal? So then again, there is an interesting judgment of Honorable Apex Court. It is in the matter of MTNL Welfare Employees Union, very famous judgment. It says that suppose there is a law, today there is a law. Tomorrow, Honorable Apex Court says that this law is incorrect and this should be the law. So it will always be prospective and not retrospective. So suppose a plan is approved and implemented. Let's say SR Steel, for example, has been confirmed up till Honorable Apex Court. But tomorrow Rainbow Paper takes a different view of a particular state tax creditor. Can the resolution plan approved, implemented of SR Steel be reopened? No. But the judgment of Rainbow will apply to all the pending matters.
will apply to all the pending applications. So a law which is declared by Honorable Apex Court will apply prospectively, except if the law itself is struck down. Like we have this recent famous scheme of electoral bond. So it has been declared unconstitutional, illegal right from the date of inception. So if something like this is being declared right from the date of inception, it's a different story. Otherwise, the law will always be applied prospectively. It will not apply retrospectively. However, I think we should also take one session sometime on the interpretation of Honorable Apex Court vis-a-vis IBC, because it's again a commercial law and there have been various judgments on interpreting specific provisions. So let us plan something. But I think queries have been resolved and we have also completed our allocated time.